This is chapter 3 of our employment law course. It deals with unionized workplaces. This will be the only chapter throughout the course in which we will be dealing with unionized workplaces. Since at BCAT this is dealt with in more details in labor relations courses. But this chapter will bring quite deal of details and information that will help everyone understand the differences and what a unionized workplace is. So the objectives of this chapter is to understand the differences between a unionized and non-unionized workplace, and then understand how a union is certified or decertified. We also need to look at activities that may constitute unfair labor practices, both for the union and the employers. We will also describe some of the main clauses, main content of a typical collective agreement, and then understanding the steps of a lawful strike or lockout, and then look at the charter. Remember the Charter of Rights and Freedoms, which we discussed on equality on chapter 1. So now we will look at the charter again to check some freedoms, freedom to associate mainly. So as an introduction, the unionized workplace is different from a non-unionized workplace in terms that a unionized workplace is based on a collective agreement. So there's a union, and the union is the one negotiating on behalf of all employees that belong to that union. A very good example here is all faculty members at BCAT. So my case, regardless if I am a day school teacher, so I'm a regular faculty member, and on the top of that, I also teach this course and other courses at the part-time studies department. So contracts are different, but still all relationships are based on a unionized workplace. So I am bound, all faculty members at BCAT are bound by the same collective agreement. And by the way, in a unionized workplace, as we'll see a little later, there is not an individual contract of employment. There is what we call a collective agreement. And this collective agreement binds everyone, the employer, BCAT, the union, and the employees that belong to that union. In our case, all faculty members. So this is the very basic distinction. No faculty members at BCAT, for example, will negotiate their own contract with BCAT because there isn't such individual contract. Okay, whereas in another company that is not unionized, then there will be individual contract of employment. So each employee will negotiate their own employment contract with the employer. And then another factors here are that, one, this collective agreement is negotiated by the union. So the union negotiates our collective agreement on behalf of ourselves. And as I said, the collective agreement will bind the employer and the union and all the employees in the bargaining unit, as we call, all employees that belong to that unit. Again, our unit is only faculty members. We're not talking about managers, directors at BCAT and others, just faculty members. And the idea here is that the union is there aiming at rebalancing bargaining power, because an individual faculty member would have low bargaining power negotiating with BCAT, such a big employer, whereas the union itself negotiating on behalf of over let's say 500 or 1,000. I'm not sure what the number is, but the union negotiating on behalf of 500 faculty members will certainly have a better bargaining power. Union has become legal and has followed what is called the Wagner Act model in 1943, and it was actually codified in statutes from 1948 on, both in the federal and provincial levels. By the way, some other examples of unionized workplaces. Teachers, elementary and secondary school here in BC, they are unionized. Transit employees are unionized. Another example, IKEA in Richmond, I know they are unionized, but the IKEA branch in Coquitlam, they are not unionized. So just are some examples. And employees got together, formed a union at IKEA Richmond, and the employer could not deny the existence of such union as long as it was properly certified, as we'll see how the process is in a minute. But the employer cannot deny, cannot refuse. Whereas employees at IKEA in Coquitlam, they have not organized a union. So some examples, our local or regional examples for you. So this model, the Wagner model, has some chief components, and they are basically the right of employees to form or join a union. So the example I just gave about about IKEA, Richmond, or Coquitlam. And then the model also deals with the certification process in a way that it creates an exclusive right of the union to negotiate the terms. In other words, after the Labor Relations Board certifies that union, no individual employees will be able to negotiate directly with the employer. Only the union will do it. And there will be a collective agreement which will have same force as an individual contract, and it will be enforced as such. There will be rules for strike or lockout. There's a duty to bargain in good faith. It is prohibited to make use of unfair labor practices, and the Labor Relations Board is the one to certify the unions and also regulate labor relations. So we'll see some of those in more details from now on. Establishing a union. So if a group of employees wants to establish a union, they need to organize themselves and then apply for certification with the Labor Relations Board, and then agree on the first collective agreement. So this is basically the three-phase process to establish a union. Some terminology that is important here for us: the Labor Relations Board, so the body that is in charge of certifying, decertifying, assessing labor relation unfair labor practices, and also enforcing um, legislation with unions and employers. Bargaining unit is the group of employees for that union. So as I said, at BCAT, the bargaining unit is related to faculty members. For teachers, the bargaining unit relates to teachers, so on and so forth. Union member is as opposed to being in the bargaining unit. So I am a member of the union. It is not the bargaining unit. Bargaining unit is the collective, the group of employees, and the member is only one employee in that unit. And union security is when an employee is a member or pays the dues. We have to pay dues at BCAT, and such dues are deducted in our pay stub. And then some types of unions. So we have union shop, closed shop, and the open shop, also known as union dues checkoff. You have more details in the textbook, but just to um, explain a little bit those. So the union shop is when the employer agrees to only hire labor union members or to require that prospective employees join the union, um, make part of the union so that they can be hired. The closed shop one is the one that the employer agrees to hire only union members. And while the employee works for that employer, the employee agrees to um, remain a member of the union. So at all times. And then the open shops, the open shop one is that the new hires, they don't need to join the union. That's the union problem, the union business. And the company itself, the employer, does not require employees to join the union. So that's why it's open. So it's an open shop. Again, union shop. So the employer agrees to hire only union members or require that new hires join the union. Closed shop can only hire from the union union members, and those union members have to remain members throughout the time they are providing services to that employer. And the open shop, the employer is not bound to hire anyone from the union. It is the union business to convince, persuade new hires to join the union. The certification process. So this is the first phase to establish a union. How does this work? Well, first of all, a minimum support level is required. So here in BC, 45% of the workers in that bargaining unit is required to support the formation of a union or the establishment of a union. So, like if IKEA, Coquitlam employees want to form a union, they would need to organize themselves and try to convince at least 45% of employees to support, and then such evidence would need to be um, informed, would need to be proved to the Labor Relations Board. And then there's an application to the Labor Relations Board in a way that they can certify it. The Labor Relations Board will determine whether that unit is appropriate for bargaining or not. So usually most employees will, the Labor Relations Board will find most employees appropriate But if they're talking only for managers or only for executive level employees, then usually the number of employees is not enough for a union. And then the Labor Relations Board will confirm the number of employees in that unit so that they can assess the 45% support level. The Labor Relations Board will order, so after they've gone through these, they will order a secret ballot representation vote. So now 50% is required, so 50% plus one. Majority of voters have to be in favor, and then the Labor Relations Board will approve the certification or will reject if the majority of voters did not vote in favor. So that's basically how a union is established by the Labor Relations Board. And then once the union is certified, then the employer must negotiate with the union. So the employer cannot negotiate with individuals in the bargaining unit anymore. And also, the certification will prevent other unions to seek certification for that unit, for that bargaining unit, for that group of employees. So once the unit is established, no other union can try to persuade employees to join themselves. And this is also known as raid. So raid is not possible for the first 6 months of the year, of every year, and um, it is not possible also during lockouts or strikes. It is only permitted during 2 months every year on the 7th and 8th month of each year. What am I saying here? I'm saying that employees may try to form another union for the same bargaining unit, however, and for whatever reasons they want, however, trying to convince the union members or raiding is not allowed only during the 7th and 8th month of each year. So the certified union has here some protections not to lose their members. The Labor Relations Board may decertify unions, and the main four bases will be because the employees themselves, the employees of that unit, the union members, they apply to the certification, or the union or the employer has shut down, or the Labor Relations Board will order the certification because of violations, legal violations. Mainly of them will be related to unfair labor practices, we'll see in a minute, or another union raids the employees. So another union manages and is successful to persuade employees to join their unions, so the former union has no employees anymore. But remember, the raid is only legal if in the allowed period, which is the 7th or 8th month of each year. And then the union has been certified. Now it is time to start negotiating for the first collective agreement. So the collective bargaining may start. And how does it start? It starts by either the union or the employer. It is usually the union, but either one or the other serve a notice of intent to the other. So in most cases, the union will serve a notice of intent to start bargaining negotiation to the employer. and then both parties must start bargaining, and they have a duty to bargain in good faith. And bargaining in good faith is a common law contract principle. It is also a principle in civil law countries or civil law jurisdictions such as Quebec. And it is a duty to be fair, to be honest, to be transparent in the negotiations. And not negotiating in good faith means or can create or can give rise to an unfair labor practice. There are no time limits once the bargaining starts. Um, the shorter the period, the better for both parties, so that discussions and bargaining do not get uh, in a negative situation because of the difficulty to negotiate. But legally speaking, there's no time limit. Again, just the duty to bargain in good faith. If the bargaining goes bad and breaks down, then the union can strike or the employer can lock out. Why would the employer lock out? The employer would lock out in case the employees start being lazy and not being as productive as they were because the bargaining is not going well. So to avoid losing money, the employer may use the lockout right, and this would impact in the employee's capacity to make money, to earn wages. So that's why an employer would lock out. We'll see some special rules a little later. And in BC, there's a special mediation options. So parties may request for mediation, and in the mediation, there will be a mediator, a neutral third party that will try to help parties to negotiate, to bargain. The mediator itself, the mediator themselves will not make any decision. The mediator is working like a counselor, like a psychologist, trying to help parties negotiate among themselves. So the mediator is there saying, hey, you should concede here, or saying to the other, hey, you are being too incisive here, calm down. So he's the one helping, but the parties are the ones reaching a decision, not the mediator. The mediator is just there to help parties to negotiate. And if mediation is not successful, parties may still have an arbitration. And arbitration is different. Arbitration is the arbitrator will be the one making a decision. So, whereas the mediator only helps parties negotiate, the arbitrator functions similar to a judge, not the real same, but similar to a judge, because the arbitrator will hear the evidence of both parties, and then the arbitrator will make a decision. Who is right? Who is wrong? But this is the last resort. And by the way, all collective agreements, they need to prescribe grievance processes, at least a grievance process, and arbitration is always there in collective agreements. So once the collective agreement is signed, is in force, so the collective agreement itself becomes enforceable. It binds the employer, the employees, and the union. As I just said, all disputes will go through the own agreements grievance process. Usually there will be arbitration there as well. And here in BC, the agreement has the status of law in a way that the Labor Relations Board uh, will have more of an enforcement role. So the collective agreement is law for all parties involved. It is law for the employer, for the employees, and for the union. And by the way, you can log on to bcat.ca, or you can just Google BCAT collective agreement, and you will see our FSA, faculty members union. You will see our collective agreement. It is a long document over 120 or 30 pages. I will upload that on Learning Hub as well, just for you to have an idea of how a collective agreement looks like. Very different from an individual employment agreement. Again, collective agreement bars rating except in the 7th or 8th month of each agreement year. And during the collective agreement, usually collective agreements are valid for 5 years. Their term, at least the one at BCAT, this is for sure. So during the collective agreement, there cannot have strike or lockout. This is known as the peace obligation. Because the agreement is in force and was duly negotiated, there's no reason for strike or lockout. If there are any issues, parties will have to use the grievance process to solve their disputes, their matters. And strike or lockout will only be possible in case the agreement ends and while the new collective agreement is being negotiated, while the new bargaining is in process, then strike or lockout will be possible. What are some unfair labor practices that are prohibited? So depending on the phase, they may be different. During the organization phase, the general rules will apply, and during the certification and the bargaining phases, there's a freeze in place in a way that employers cannot change wages, either up or down, cannot change the working conditions, regardless of the motive, regardless of the reason. Even if the employer is facing some financial downturn, they cannot change during the certification or bargaining phase. And for periods that are not in the freeze moment, as above, the general rules again will apply. So most complaints with regards to employers are related to refusing to bargain in good faith or interfering in the formation of a union, trying to persuade employees not to form a union. And there's also discrimination in case the union is in strike, employees are on strike, and employees decide not to work. They decide to join the strike. They refuse to cross the picket line. So sometimes employees are threatened to be dismissed. Those are the main unfair labor practices related to the employers. The general rules when they are related to the unions. So examples of unfair labor practices related to the unions are that sometimes union representatives they intimidate or coerce employees, or they even restrict employees to communicate among themselves because they want everything on the union. They refuse to bargain in good faith as well. or refuse to admit members due to discrimination. And here it could be gender, could be ethnic origin, could be religion, could be sex, etc. They also negotiate with the employer when another union is certified, and they try to punish members that work during illegal strike. Well, if the strike is legal, it is fine, but if the strike is illegal, they could not punish members. So those are some of the or the main unfair labor practice, both related to the employer and related to the union. Now, looking a little bit at the collective agreement. So the collective agreement is a written agreement between the employer and the union. It will contain conditions and terms of work, and it may also include other documents by reference. So it may say that work and safe work, health, safety, rules, regulations apply. It may say that specific governing bodies certification applies for some professions. So they may include other documents as long as those other documents are legal by reference. It depends on the negotiation of the parties. And some common elements that are in the collective agreement are that the union is established as the bargaining agent, and also it defines the union, such as I said, faculty members. It will set out the terms of work, so pay, hours, safety, benefits, etc., and they will be valid for everyone in the bargaining unit. In other words, all faculty members at BCAT, they get paid the same. There's a difference in seniority and experience, qualification, but that's the only way to pay differently. 2 or 5 or hundreds of faculty members who are in the same, who have reached the same seniority level, they will all be paid the same, regardless of what course they teach, what qualifications they have. So at BCAT, every year, faculty members may move one step up if they work full-time. There are some requirements for that. But the rules are the same for all faculty members. What I mean here is whether a faculty member is a really, really successful professional or not, they will get paid similarly to others in the same seniority level. And then there will be a framework for dispute resolution. So as I said, there has to be a grievance process, such as obligation to negotiate, etc. And in most collective agreements, there is an arbitration process there. The collective agreement, as we know, will override all individual contracts that were valid before the union formation, and it also imposes the peace obligation. Remember, there can be strikes or lockouts during the collective agreement. So the union is more than an agent. It is also a principal. In other words, the union is the one concluding the agreement. The union does not need to have all union members to sign the agreement. If they were only an agent, then the union members would need to sign the collective agreement. But no, the union is not only an agent. The union is is a principal as well. So they can conclude the collective agreement on their own. And most unions will require the collective agreement to be ratified by their union members. So there will be a vote to ratify on the new collective agreement. But this may be a requirement of the union. The Labor Relations Code itself does not require ratification. So BCAT has just concluded a new agreement with our union, the faculty members, and in our union, we have to vote to ratify, to confirm we agree with the union, with the negotiated terms of the collective agreement. And we voted last year, at some moment last year. But this is not, again, a requirement of the Labor Relations Code. And then the collective agreement is the employment contract. Will be a complete rule book for all employee relations, and it will displace most employment standards law. So in most cases, the Employment Standards Act does not apply because the collective agreement itself is so extensive that it deals with all situations in the workplace. However, the relationship of the union members and the employer is still subject to health and safety, privacy, human rights legislation that are always applicable. We have to look at a case law here, the McGavin Toastmaster and the AINSCO from the Supreme Court of Canada. So this case law teaches us that once the union is formed, there's no individual contract of employment, so there can't be any exception. Everyone in the bargaining unit will be bound by the collective agreement only, and also whatever the grievance process or disputes and rules are in the collective agreement, those have to be followed. Even if there's a major violation of the agreement, the grievance process or the dispute sections in the agreement, they will have to be followed. And another case law that is important for us here, the Isidore Guerin, also from the Supreme Court of Canada, says that general legal rules that supplement the collective agreement, but that are also consistent with the collective agreement, so are in harmony, are not conflicting, they can also apply to solve disputes, to solve issues. So other laws, other legislation that are consistent with the objectives, with the terms of the collective agreement may be applicable in case they are needed. So parties may want to claim to use them. So once the union and employer get a tentative agreement, in case ratification is required by that specific union, then the ratification will begin. In other words, the union members will then vote to approve or not that tentative agreement. And then if rejected, parties will resume bargaining. If accepted, it is signed, then submitted to the Labor Relations Board, and it becomes a binding contract and valid. Some terms that are required to be in the collective agreement, so peace obligation, we just saw, just cause requirement for dismissal. In most cases, there's only just cause dismissal. There can't be dismissal without just cause in most cases. That's why being hired by a unionized workplace takes time, because once you become a regular um, you have some job security. I can explain, I can exemplify to you the case for BCAT. So I was a temporary faculty member for 3 years, and just last September I became regular. So because from now on, just cause is required to dismiss me, or some other uh, specific or extenuating situations. Let's say business goes really, really down, but those are very, very specific requirements. If those are not in place, only if I give just cause to be dismissed. So if I commit illegal acts, or if I'm not performing well for consecutive years, even though I've been warned, etc., etc. So the just cause requirement has to be in the collective agreement. This I already said, the grievance and arbitration process, and also this technological change section, meaning that the employer may change uh, the technology used to for the employees to perform their work, and the employees agree to um, accept this technological change by the employer. And also duration has to be there, minimum for 1 year. In our case, the FSA, here at BCAT, our agreement is valid for 5 years. There's some common terms. Those are not required by statute, but they are there. Again, I told you our collective agreement is over um, 120 pages, if I'm not mistaken. So that's a lot of term sections. But some are recognition clause. So the collective agreement recognizes there's a union, that is the correct union, etc., etc. The union security clause, whether it is open shop, closed shop, there's a preamble usually. So whereas in the benefit of this, so it is the introduction of the collective agreement, some definitions, and when definitions are in the agreement, whenever there's a doubt about those terms, the definition section has to be checked. Management rights, and etc. So, talking about the grievance and arbitration process, so the labor relations code requires at least a basic process in the agreement, and in most cases it is arbitration. But there can also be multiple steps before arbitration. So, for example, parties have to have to sit and negotiate. If the negotiation is not successful for uh, 30 days or 60 days or 6 months, then there has to be a mediation. So multiple steps can be present there. And the last resort would be arbitration. So in case disputes cannot be resolved by parties, then arbitration will take place. The Labor Relations Board, they hear some disputes here in BC, and after the Labor Relations Board, for those some complaints they hear, or the arbitration decisions, the arbitration decision is made, um, there may be judicial review, but in very limited circumstances. In most cases, courts will not interfere, either in their both in the arbitration or the labor relations board. So very limited circumstances. Best example here would be if the process is not fair. Let's say either the labor relations board or the arbitrator is acting in a biased way towards one of the parties, then this is not legal. This is unfair. So courts could interfere here. but very, very limited circumstances. This would be an exception. Strikes and lockouts. So this is a right for unionized workers. Individuals in individual employment contracts, they do not have such a right if they don't like anything that is happening, so they can quit, but they cannot go on strike. And it exists as an element of negotiating leverage. And the two main issues we need to learn here, assess here, are when can the union strike, or when can the employer lock out, and what activities are allowed during a strike or lockout. So when are they legal? They are legal if a union is certified. Again, there can be strikes or lockout during the life of the collective agreement. During the bargaining, good faith bargaining is required first. If there's a mediation, the mediation has to be concluded if the mediation has already started. If employees want to go on strike, there has to be a vote approving the strike. So the union members, the majority, have to approve the going on strike. And even if the strike is approved, but before the strike starts, if there's a last offer from the employer, then the union has to perform this last offer vote to either change their minds and don't go on strike, or to delay the strike. So those are some requirements. And the strike vote procedures, they are made on secret ballot. Majority 50% plus one must support, and if it is approved, a 72-hour notice has to be served on the employer. And if there's a mediation taking place, the mediation must must finish their mediation report before the strike can start. And the strike can actually only start 48 hours after the mediation report in BC. And if there was a strike vote, but then the employees have decided not to go on strike yet, even though the strike was approved, such a vote or the voting process is valid for 3 months. If 3 months have gone and they want to go on strike again, then a new vote is required. So the strike can start at any time after 72 hours, but before the 3 months. And for employers, there's no need to vote for a lockout unless the employer is part of an employers association. Then similar rules would apply. And the bargaining should continue during strike or lockout. Actually, it should be emphasized, parties should actually work harder during a strike or lockout, because parties are suffering during this moment, and they are actually using either the strike or lockout as a leverage to keep on bargaining. What are activities allowed during a strike? So employees, if the strike is legal, the employees can withdraw their services. They can leaflet, they can inform the public what is happening, why they are on strike. In BC, peaceful picketing means they can leaflet, they can communicate their message to the public on public land, and on private land where public has access, for example, mall or office building. And a secondary picketing is allowed. So a secondary location of the same employer is allowed. but there are some restrictions there. Uh, Activities that are not allowed. So trespassing on private land. Trespassing here meaning being on someone else's land. In this case, private land without authorization. Torts are not allowed, such as nuisance. Nuisance means interfering with someone else's enjoyment of their property. Conspiracy, so conspiring against the employer or other people, for example, managers who are making it difficult to negotiate, etc. Intimidation, inducing breach of contract, so inducing employees to breach their contract, defamation, making false statements, and assault, threatening others. So those are all prohibited activities. They are torts. They actually um, attract liability. But the mere act of picketing and leafleting, they are not considered a tort anymore. So common law used to consider picketing and leafletting a tort, but new legislation was passed and they are not a tort anymore. And watching and besetting or threatening individuals, not allowed. Criminal laws may apply here. So sometimes employers would have their senior executives or managers to watch and threaten some key union members so that they would try to stop the strike. Criminal laws here would apply. When workers are on strike, they continue to be employees, even though they are not being paid. They are entitled to return to work as soon as the strike ends, and they are entitled to continue their benefits while on strike. Activities not allowed by the employer. So the same torts we just discussed. Employers cannot dismiss employees at the end of the strike, nor can they hire replacement here in BC. Some other provinces allowed, in Alberta may be allowed some circumstances, but in BC they cannot. For essential services, so firefighters, health services, police, other governmental services. So the Labor Relations Board and the Minister of Labor, they can designate a minimum number of employees that have to be working because essential services cannot stop. And then those designated workers will not be able to be on strike or locked out. And here in BC, there's no flat prohibitions. The process will be led by the Labor Relations Board. So in other words, the Essential Services Agreement can be negotiated in a way to designate only the truly essential workers. So in other words, there isn't a flat number there. So in each case will be assessed on a case-by-case basis, depending on what the essential service is. So now the last part is looking at the Charter of Rights and Freedoms related to the unions. Most relevant rights from the Charter will be the freedom of expression and the freedom of association. Remember, I may have told you, or if I haven't, I'll say now. Freedom of expression is limited, is not absolute. So we have the freedom of expression, however, we cannot, for example, express false statements about others to third parties. This is defamation. So in other words, the freedom of expression is limited on exceptional basis, but it still is limited. It is not a freedom without boundaries. No, there are boundaries there. So just remember that. So the Charter applies to all laws that govern workers and unions, and also to government employers. The Charter does not apply to private employers, and cases related to the Charter and the unions, they will usually deal with whether a charter right has been violated or not, whether the freedom of expression or freedom of association has been violated or not. And in case the violation is there, the exception under section 1 that I told you on chapter 1, whether such violation is justifiable. Remember, whether it is justifiable in a free and democratic society. Remember, I gave you the example of the health order, the restrictions, which, by the way, were extended this week until February 5th. So whether it is justifiable in a free and democratic society. So we'll look at some case law, some cases here. In terms of freedom of expression, the decision from 1986, the Dolphin delivery from the Supreme Court of Canada, the decision tells us that primary picketing is protected as freedom of expression, so they are legal. Secondary picketing at other employers' locations, they are not protected as freedom of expressions, and common law has banned them. They can still happen, but in a very limited way. And certain activities are not protected, and this is quite logical. So violence, threats, trespassing, and unlawful activities. So those are never protected as freedom of expression. But then in 1999, the UFCW versus Kmart, so the Supreme Court of Canada changed a little bit and decided that leafleting at secondary site is protected as an expression. So they broadened the protection for freedom of expression as compared to the 1986 case, the Dolphin delivery. So it was a victory for the unions, even though they only dealt with leafletting at secondary locations, not other activities. Yet, under the freedom of expression, we have this Pepsi-Cola case from 2001. And here, the victory for unions went even further, because the Supreme Court of Canada said that any common law rule that were against secondary picketing would violate freedom of expression. So here the Supreme Court of Canada emphasized the importance of unions and their strike of activities, and made it open for secondary picketing. They obviously maintained, kept that illegal activities, unlawful activities are not allowed, are not a form of expression, such as trespassing, other torts, as we discussed. In terms of freedom of association, so there were two eras, as we can say. So the 90s, 80s and 90s, in which there was a narrow interpretation of association. At that moment, unions as collective, they had no real rights. but then after 2000s, there was a growing trend to protect the right to form unions and also to bargain collectively, even if statutes would prohibit. This case is important because it deals with the freedom not to associate, Levine from 1991. So here the college professor was objecting to the union's use of dues to support political party, and the court here found that collection and use of the dues would not unjustifiably violate his freedom of association. So 4 judges here decided that freedom not to associate does exist. 3 judges rejected the freedom. So there was a majority decision here in favor of the freedom not to associate. So if you don't want to associate, you are not required to, as per Levine. It was not a unanimous decision, but a majority one. And still with regards to the freedom of association, we have the right to bargain collectively. The main case here would be the Health Services, Supreme Court of Canada again, 2007. In that case, the BC statute had removed major terms from the Health Service Union agreements and barred renegotiation of the collective agreement. And then the Supreme Court found that the statute, the BC statute, violated the Charter unjustifiably. So violation of the Charter is allowed in exceptional circumstances, and then, but only when it can be justifiable in a free and democratic society. If it is not justifiable, then it is illegal. Courts will strike it down. This is what the Supreme Court of Canada did here with the BC statute. So this is what I wanted to share with you with regards to unionized workplaces. There's a mistake here. It is saying provincially regulated employers, but that was chapter 2. So that's it for chapter 3. Thank you for now.